members of the Zoning Board of Review. My name is Steve MacGillivray, represent the appellants tonight. First want to start off by thanking you for holding a special meeting and coming out tonight to hear this appeal, only giving us the time. I appreciate it. I'll also start with a point of agreement. I think Mr. Heitz has elucidated and explained the standard correctly when it comes to the evidentiary standard. And I'll be arguing under that standard. I think it still should be reversed under that standard. And then in terms of a preliminary remark, I'll say, I was here with you all not too long ago. Room was much more crowded, and we were all under a lot of pressure. But that was a project that my clients and quite frankly, I thought was a bad project for the town. This project is different. This I think is a good project for the town, and my clients agree. This building, this mill building, should be used. It should be put to good use. It will serve to improve the downtown and waterfront area of Bristol. What we're here tonight really is to talk about doing it in the right way. Not shutting it down, doing it in the right way. So I just wanted to make that clear up front. So Mr. Alvario very kindly prompted me to explain exactly what the grounds for our appeal are. And they are as follows. The density allowed by the zoning board was incorrectly calculated. Okay, so this would probably fall under a number of the standards. I'll start with the clear error standard because I think they just did it wrong. And I think a good definition of clear error is when they just got it wrong.
You meant the planning board.
The planning board, I'm sorry. Did I say zoning board?
You said zoning.
Oh, boy. You guys aren't going to get along.
Don't hold it against them.
And then we'll also talk about the evidence that was presented to support that decision on density and how it was presented. It was from in a form that has no evidentiary weight and therefore is contrary to the clear weight of the evidence, which again is kind of that second standard you heard. And then third, we'll talk about how public comment should have been reopened after new evidence was included. And that goes to the third standard, which is they made a mistake in the process. You can send it back and have them fix that process. And those are all density. We'll talk about those. And then the other part that my clients are concerned about, besides the density being excessive and contrary to the ordinance, is the affordable housing element. The applicant has asked for, and the planning board has approved, a fee in lieu, where they pay a fee instead of actually creating affordable housing either at the project or at some other site. And that's contrary to the zoning ordinance. So that would be clear error of law. They got that one wrong. And then there's a final issue where they've gone and amended the zoning ordinance that applies to this building between when the planning board heard it and when you heard it. And I think after the decision came out from the planning board, they actually sent in an application for the zoning change. And they called it an amended application, but it was a new application. And they didn't follow the process for sending that to the planning board, getting a recommendation, and coming back and then going to the town council with it. They didn't do that. And also, getting a little bit into target, there's other processes I'll go from where I thought that was done incorrectly. But anyway, let me start off with the density aspect of this. The statute that was in place at the time that the planning board heard the application required that there be 2,250 square feet of gross floor area for each unit. And gross floor area in the zoning definitions, and I'm going to quote here, means the sum of the gross horizontal area of all floors of the building measured from the exterior face of the exterior walls. That kind of makes sense. But not including interior parking spaces. And then it goes on to say, or space where the floor to ceiling height is less than 6 feet. But it's not to include interior parking spaces. I'm gonna, if it's okay, Mr. Olivero, I just have a piece of the record that I'd like to give to him so they don't have to flip through the
Yeah,
record.
that's perfectly appropriate.
I'll give a copy to Mr. Tights.
And it explains your position, and all the better.
This is all in the record already, so this is not an exhibit, correct?
This is not an exhibit, it's already in the record, but instead of you flipping through the reams of paper in front of you, I thought I'd give you the actual piece of paper.
Mr. Chairman,
Yes, sir.
may we have the specifics of, in the record, there were different versions of the plans that were submitted over time, and I can't tell on this one with the fine print, I don't know what the date is on this when this was submitted, what part of the record this is from.
I can't read the date on that, actually.
Right, so I would ask Mr. MacGillivray to properly identify it, or I would object to it.
Was it part of the record upon which the planning board made the decision?
It is part of the record, and it's, my understanding is it was part of the application made by the applicant. These are their engineer's drawings.
And were these the ones submitted on December 1st with the application?
That's
Dated
right.
11 As I'm claiming, were these the ones that were submitted later in March? That's my question.
Yeah.
Because the plans did change over
Yeah,
time.
these are the original plans submitted, is my understanding, with the original application.
What is the handwriting? The
That's my handwriting, and that's why this is not an exhibit. This is just my attempt to explain to you.
Because there's two different numbers.
There are, and so that's kind of a, I guess what they would call a demonstrative in court, where I'm just using it to explain what the record is, but it doesn't become part of the record.
Okay, so we're going to call this as the original set of plans, that was the original application, correct?
The original applications. Yeah.
So that's, yeah,
And
that's,
if Mr. Tights wants to present the later plan that was submitted with the application, well, that's fine too. But
I would not object to that.
Right, sorry.
So in any event, this is the calculation, if you look in the upper left-hand corner of the buildable area, according to the applicant's own engineer, and you'll see that it adds up to 292,745 square feet. But if we take out the lower floor, which is this basement floor plan here, we get 2,027,285 square feet. So that is the gross floor area of the building. And under that gross floor, there would only be, let's see, I forget exactly, 101, I believe, space units allowed. So that's the error right there.
So that lower level, what you're saying is the parking level, they counted the parking level.
The count of parking level, you're not allowed to, under the ordinance. So, what they did is they then came in after the close of the public hearing. They added, as part of the draft decision, again, public hearing closed, board says, go out and, Mr. Solicitor, draft us opinion that's in line with what we're doing. For the first time, in that draft opinion, is referenced the tax assessor's property card. And the tax assessor's property card has an entirely different name. They call it, they don't call it gross floor area, they call it, but it's 296,717 square feet. So different than the applicant's own engineer, a little bit larger. That comes in, again, after The informational hearing is closed, and I'm gonna, if you don't mind, here's a copy of the property.
I do object. It's not an evidentiary hearing. It's in the record, he's got an argument, he's already told you what the property card said. I don't think there's any need to provide a copy of this as well.
Well, it's already in the record. If it's already in the record, he's using it as illustrative of his argument. I think he's trying to make a point.
There's nothing new.
There's nothing new here, so I think...
There is, because there was his handwritten note on this one, and on the tax card, there's information that's highlighted. He's got a couple of sections highlighted, so he's using it to create an evidentiary exhibit.
If I may, I'm not even sure that this tax assessor's card, even though it's a public record, was in the planning board record anyway.
It is.
So what's your name?
John McCoy.
So, well, you can let him make his argument. Why don't we hold this for now, is my recommendation. Well, I'll take one.
Sure.
But why don't we hold it for now? And you can make your points, Mr. MacGillivray, without submitting this right now.
Okay, well,
And you have your memo, but go ahead.
certainly. So in my hand, but not in your hands, is the property card from the town. It was part of the record, and it is alluded to in the decision. The decision says, according to the property, the tax assessor's property card, the GFA is 296,000 square feet. Again, slightly higher than what the engineer accounted for on all floors. Take out the basement and it's much higher. Just grab my notes here. And so this came in after the public hearing was closed. And there's case law in Rhode Island that's very clear that if new evidence is presented after the public hearing, you have to reopen the public hearing. Nobody ever got a chance to comment on this number. The tax assessor didn't appear to testify. Moreover, the property tax card states that it's only, and I'm reading from the top of it, summary data, and it may not be complete representation of the property. It also has an explicit disclaimer on the side. And that disclaimer says, and I'm going to quote it word for word, "This information is for tax assessing purposes and is not warranted." Okay, so there are two issues there. There's one, the process, prejudicial process. This was included for the first time after the public hearing was closed. Clearly prejudicial. It's relied upon, if you read the decision, page 1 of the decision says, according to the tax assessor's record, the subject mill property contains 296,717 square feet of gross floor area, not including the basement, which allows for a residential density of 131 dwelling units. Okay, so that's an explicit finding based on this property tax card. They also, in a finding of fact, I think this was on page 8, but it's number 3 of the findings of fact, they state, and this is the finding of fact law on which they base their decision, the proposal complies with the density requirements of 28-284 D2. So they're saying, hey, we've got enough GFA for 131 units, and this applies. The problem is, new evidence didn't reopen it. And then the third grounds here is the weight of the evidence. Okay? So before you have the applicant's own engineer's calculation of what the GFA is, and it's 227, much lower. So that's the only evidence that was presented during the actual hearing. This came in later. Shouldn't even be in the record. Shouldn't have been relied on. Moreover, it explicitly says it's for tax assessing purposes. So this is where we go to the weight of the evidence argument. On one side, you have a calculation based upon the applicant's own engineer's calculation, and on the other hand, you got this thing from the tax assessor, and he's telling you, which wasn't testified to, there's no sworn testimony that said, this is how I came up with the number. In fact, on the actual document, the tax assessor's telling people, don't lie on this, I'm just using it for tax assessing purposes. So it's kind of explicit. So you get the three grounds there. It's just wrong, so that's the clear error. You got the process problem, where they didn't reopen the hearing after the evidence was somehow made its way into the record. And then you have the weight of the evidence. The applicant's own calculation by a trained engineer, where she measured the space compared to the tax assessor who's telling you don't pay attention to this thing for any purposes besides the tax assessment. And the overall thrust here is, if it was a slightly lower density, we wouldn't have an objection to it. If it was the density that was allowed under the ordinance, we would have an objection to it. So the next issue is the affordable housing issue. The state, as you know, the state requires towns to provide affordable housing, and most of the cities and towns are struggling to get up to the percentage. I'm not an expert in the area, but I know that most cities and towns have fallen short and are constantly trying to get there. And in furtherance of that, Bristol has section 28370, inclusionary zoning, which they amended in 2021. And that says that it doesn't provide for fee in lieu anymore. So it used to be you could pay a fee instead of providing affordable housing on-site or at an alternative location, or pay a fee. We have those three options. Now you only have the first two options after 2021. No fee in lieu. Now the applicant says, well, we're grandfathered because there was a 2008 zoning change that allowed us to have 98 units, which is interesting that back in 2008, the town council thought 98 units was appropriate density. But we're grandfathered under that because that allows for fee in lieu. Well, that's something that happened in 2008. 2021, this ordinance was changed, and I'll read you from the applicability where they tell you what this applies to. 28370A, applicability. This section shall apply to all subdivisions of 5 or more units and all land development projects, including new development and redevelopment of existing buildings with 5 or more dwelling units, as classified under the Bristol zoning ordinance and subdivision and development review regulations. Fairly blanket statement in 2020. This applies to everything. So their action in 2008, they don't say, oh, except for 2008, you know, that's grandfathered. They say this applies to everybody, all of these types of projects, and you no longer can do fee in lieu. The planning board approved fee in lieu request, which again is clear error of law. Okay. And when you hear the term grandfather, I'll just say this: grandfather, people use it kind of colloquially, but it has a very specific meaning. It means physical existence of certain things on property that were there prior to the zoning ordinance being enacted. Usually, I think it's 1971. Mr. Types a little better than I. And those things are allowed to stay because it would be unfair to suddenly change the rules on people who had something with a non-conforming lot or some other non-conformance. This is not that situation. This is 2008. The town council did something. In 2001, they did something else. Now, the final of the arguments has to do with the request for the zoning map change. This was made, and I'm not going to try to pass this up to you because it will throw an objection, but there's an application in your packet, in the record, which was, it's a application for zoning map change. And the date is May 23rd, 2022. So a new application for the zoning map change was made in May of 2020, May 23rd, 2022. That, as you may have realized, is after the date of the decision, which is supposedly recommending the zoning change. And that's because the zoning board didn't have that, the planning board, I keep saying, the planning board didn't have the language that was requested. So they filed a new request. That request was supposed to go to the planning board, as I said, under the ordinances. They make a recommendation, and then it goes to the town council. They didn't do that, obviously, because this, you just look at the dates, May 23rd is after the decision. New application, they didn't follow the rules, didn't go to the planning board for a recommendation as it needed to. The other area, and I'll just mention this because it also, I think, touches upon some of the arguments that we may hear later. When you take an appeal from the planning board, under 28.410B, all proceedings and furtherance thereof, furtherance of that application will automatically stay. Okay? So it's our position that the town council shouldn't have even done anything. It's supposed to freeze in place until you folks could review it. Instead, they went ahead and they purported to conditionally change the zoning ordinance to get rid of the density requirement. Shouldn't have done
Doesn't that, Mr. MacGillivray, doesn't that just apply to proceedings before the planning board? The town council is the legislative body of the town and has their own rules by which they are governed, and it seems that what you're challenging is really a collateral attack on the process employed by the town council, not the planning board.
No, because I would disagree with you. Again, this is all part of one proceeding. The decision was conditioned upon this town council approval. So it's a further proceeding or proceeding in furtherance thereof. It doesn't say previous proceedings before the planning board. In fact, there's case laws out there that says you can't give a building permit, you can't do anything. It's all stayed while there's an appeal. So if the planning board approves something, nothing can happen until an appeal is heard. All right? And there's one exception to that. Is when the town says that something's going to threaten, I forget the exact wording, but basically like life and safety. Okay? So if there's a building out there, planning board approves something, and someone appeals, and the building's going to fall down on someone, the town can certify to that, and they can proceed and give them a building permit or whatever they need to do to make the situation safe. Okay? So the statute specifically, I mean, if it applied to the planning board, one would think it would say all proceedings before the planning board should be stayed. It says all proceedings in furtherance thereof. I'm going to address the other argument about why the change should apply here.
Okay.
Just because I think it's going to come up.
Yeah.
So you'll hear an argument that you should.
I'm sorry, but you listed 3 reasons, and I think is this more reasons that you're addressing?
There are actually 4 reasons. So the fourth is this procedural error in how they didn't follow the rules. The town council, the zoning amendment application didn't go to the planning.
I'm just trying to keep organized as far as the 3 items that you brought up.
Yeah, and I think I
And
said.
what's the 4th item?
I think you're obviously listening very closely because I think I did say 3 at the beginning and then I went to a 4th. I'm going to touch upon what
What is the 4th?
The 4th is this procedural failure where after the decision was rendered, the applicant filed an application for change of zoning ordinance. And it didn't go to the planning board. it just went right to the town council, and the ordinances require that go to the planning board first. There's no exceptions to that. The other problem is, in our view, it violated this automatic stay that goes into place. So there are two. Now, so those are the four grounds of our appeal. I'm going to just address a legal issue that Mr. Oliveira will probably give you further guidance on. But it's, what you'll hear is, hey, you should be applying the changed ordinance that the town council just changed in between when the planning board issued its decision and tonight. And we think that's wrong. We think you have to step into the shoes of the planning board at the time that they looked at this. And you'll recall, they said it meets the existing statute. We're saying that that's wrong in terms of density. They said that they have 296 according to the tax assessor, and therefore they can get 131 units. They're only asking for 127, so they said, as part of their findings of fact and law, it complies with the existing zoning ordinance. We disagree for the reasons I've explained. The reason why you shouldn't apply the law as it has been changed just recently, one is this automatic stay. Everything was supposed to be stayed. But two, the approval of that ordinance change was done conditionally, meaning something else had to happen before it comes into effect. It's approved conditionally pending the planning board's approval of, I believe, final plan approval. Okay? So it's not in effect yet, it's a conditional approval. And at this point, tonight, we sit here, it's still just a conditional approval. It is not, or a conditional change in the zoning ordinance. It is not in force and effect. Again, that change took out the required GFA, gross square footage, or gross floor area, excuse me, and basically left it to the planning board to determine the appropriate density based upon a number of other factors. We say don't apply that, it just happened recently, it should have been stayed, and it's only conditional upon final approval by the planning board. So, if anybody has any questions, have an answer.